Good afternoon.
Good afternoon. How are you, sir?
Wait, I can't hear. Hold on.
Is Google doing this?
Okay, good afternoon, Your Honor.
Good afternoon, sir. How are you?
Fine, thank you.
Give me just a minute. We'll get everybody in. Latrice,
Yes, ma'am.
your last name, please.
Moody. My first name is Quaterians. I was trying to change
I
it.
see that. Nope, I'll fix it on my end. Thank you so much, though.
Okay.
And there is someone here from Mr. Levine's office.
Yes, Your Honor. Good afternoon.
Good afternoon, Mr. Horn. Do you need to speak to Miss Moody?
Is that which property are they with?
Wellesley Town. Oh, nope, that's not you. Sorry.
Okay, that I was just double checking. Thanks.
No, that's Mr. Rabbit's office. But Miss McEwen is here for Equity Trust.
I can speak to her, Your Honor. I just don't know what much there is to discuss.
If you would like to, sir, you can go into a breakout room. I'll put you in there. Ma'am, you'll see an invitation to join the attorney in the breakout room. Please go there. And when you're ready, come back out. I'll get the case called and get you on with your day.
Your Honor, this is Attorney Ian Morton. You don't have an objection if I move matters around, move people into a breakout room, do you?
Absolutely not. I thought that, yep, you're already co-host. You have
Yep.
a waiting and a meeting room.
And Your Honor, this is Attorney Robert Visconti. I'm with Aaron Cox's office. I believe we have just one matter, and I just wanted to confirm that we submitted a dismissal on it. It was Swan Creek versus Dixon.
I did receive that in 225-449 Swan Creek versus Dixon. The only question was that someone conveyed to Ms. Dixon that she did not need to appear.
Your Honor, the information that I was provided is that the resident has vacated the home. So I don't know whether she intended to appear today or not, but I did not convey to her that it was dismissed.
I signed it this morning and it's already back downstairs. So if that's the only thing that you had and you want to take your leave, I understand. If she shows up, I'll tell her that it's already been signed.
Perfect. Thank you, Your Honor. Have a good day.
You too, sir. Thank you. No, I'll do when I get done. I appreciate it though. I know you will. And the fact that we would is sufficient. Because they're separated into like 4 different piles. and
That's why I thought I better check it before I.
No.
Thank you, I
Okay.
appreciate that.
You're welcome.
Leaving it early today.
I saw that. I was gonna send something snarky back and just gonna say, I don't remember authorizing that. but- Yeah. Mhm.
We're meeting in Clarkston. Probably pick that way out there, I don't know, but one of the girls is in from New York. Somebody else is in from Virginia. And then another girl's coming down from Bay City.
Oh, so this is probably
So
good.
it's- yeah.
Okay.
And then I'll go, and then the others, the other girls from Holly,
Okay.
and then,
That makes sense now.
and then one's from Livonia and Dearborn Heights, and then me. So I'm gonna meet the girl in Dearborn Heights, and then her and I'll drive together.
Nice.
So yeah, we haven't seen each other in a long time, you know, chit-chat back and
So it's
forth.
gonna be 4 hours of
Yeah,
wonderful.
so I'm looking forward to it.
Good.
It'll be different.
Well, have fun and behave.
Thank you, I will. Then I still have to drive home once I get to Dearborn Heights.
This is 2262224 LT Equity Trust versus Tamika McEwen. May I have your appearances, please?
Good afternoon, Your Honor. Eric Wine for the plaintiff, P56893.
Ma'am, turn your camera on and state your name for the record.
Tamika McEwen.
Thank you. Today is the day and time set for hearing on the plaintiff's request to lift the Sarah stay order. Mr. Wine, how are we proceeding this afternoon?
Your Honor, my client is requesting a judgment. They received no funds. Ms. McEwen was never, she never applied for SERA funds.
It wasn't Sarah.
I know,
it wasn't
Ms. McEwen,
Ma'am, no.
Okay. Yes, ma'am. Yes, ma'am.
Mr. Wine, apologies. She didn't apply and
And we have received nothing from FIA or any other source. She owes rent back to October in an amount of approximately $8,000. My client is asking for possession at this time that a judgment would issue after 10 days.
not approximately. What's the exact rent to retain possession, sir?
$79.50,
And then court cost of?
$164, Your Honor.
Thank you, sir. Ms. McEwen, what was it that you were going to say, ma'am?
It's not Sarah, ma'am. I didn't apply for Sarah. I applied for FIA. And I talked to my worker yesterday and she told me that she was gonna check with her manager to be able to call them. And I don't know if she called them or not, but she told me, and the amount he's saying is not correct. It's $62.50.
Ms. McEwen, do you have something, a document that shows that it's a different
I-
amount than what Mr. Wine has just indicated?
Yes, ma'am, I sent it to them. It came from FIA, the amount.
The
And
amount
they,
that-
yes, they
Ma'am, hold on
paid,
1 second. Couple things.
yes, ma'am.
FIA is telling Equity Trust what their balance is. Is that what you just said?
Yes, at the time it was 57 something, and I sent that to them. I actually emailed it to my landlord and also the realtor that helped me get it in here. I talked to my worker yesterday and she told me that she was gonna call them and the check was being sent out. That's all I know. I
Ms.
asked
McEwen,
her
what-
if I could include them on my call. And she told me she had to get permission from her manager to do something like that because of HIPAA.
let's start with the basic part.
Yes,
This
ma'am.
court calls it plaintiff's request to lift the Sarah stay. When I say Sarah, that is a generic term for any COVID emergency rental assistance funds. The source of it is not a particular concern to me. And when this court stayed these proceedings back on January 12, 2023, I'm pretty sure that Mr. Wine objected to it, and the court stated anyway to allow you time to make an application because you were just making the application at that time. The court
Yes, ma'am.
allowed you the same courtesy as anyone else pursuant to Administrative Order 2020-17 and would have allowed 30 days for you to complete your application, submit all documents, and have money paid out to your landlord. We
Yes,
are now more than 30 days. We are 62 days past that stay.
Yes, ma'am.
According to the administrative order, as well as the letter that this court mailed out to the parties on January 11th, if your landlord had not received full payment from Sarah program, again, generic name for rental assistance, the plaintiff could come back before this court, indicate that they had not received payment in full, and they would be entitled to entry of judgment, which is what I would have said to you when we were here back on January 11th. Mr. Wine has already said that his client has not received payment. That's number one. Number
Yes, ma'am.
two, FIA saying that a different amount is owed does not make a different amount owed is what the plaintiff is able to prove as past due rent. So unless you have something from Equity Trust that shows a different amount of past due rent than $7,950, this court will be entering is lifting the Sarah stay or the rental assistance stay and will be entering a judgment for $7,950 in rent, $164 in costs. Do you have something from Equity Trust that shows a different balance than what Mr. Wine has put on the record?
I just know, my rent is $1,250 and for 5 months, ma'am, that's what that equals out to be.
And I've included March rent, Ms. McEwen. You owe 6 months rent.
And my March rent, I don't pay until the 25th. Because that's when my check comes, on the 25th.
Right.
So March isn't due yet.
Well, your lease says that it's payable on the 1st. You may pay it on the 25th with a late fee, but as of today's
No.
date, the client has confirmed that you owe $7,950, and that's what we're requesting from the court.
Okay, yeah, but my check doesn't come until the 25th. And when I signed the lease, and you can see my first payment was on the 25th, and that's when I've been paying on the 25th when my check comes, sir.
Okay, I'm just giving you the amount that you actually owe right now, and if you pay it within 10 days, you'll be able to stay.
Okay, so Judge, so what happens if the check comes to them? Then what happens, ma'am?
Well, this court is entering a judgment this afternoon. Mr. Wine's office will send it over that after hearing, there's $8,114, which is the past due rent plus the court costs to date. That judgment will allow you 10 days to move or vacate the property before your landlord makes an application to, if they don't receive payment in full, before they are able to remove you from the property, they have to submit a request to the court for an order of eviction. And that would have to show any monies that have been paid. If you get a check for 6,000 some odd dollars from FIA and it goes to Equity Trust, then you still have to make up the difference in that 10-day period.
Yes, ma'am.
So if you pay, you can stay. At the end of the day, Equity Trust just wants to be paid what they're due in past due rent and court costs. So $8,114. Mr. Wine's office will submit that judgment by email, sir.
Yes, what is that address, Your Honor?
It's civil at MI 34th District Court -mi.org. The court will sign it, ma'am. A copy will be mailed to you at the address we have on file. Anything else on behalf of Equity Trust?
No, Your Honor, thank you.
Can I ask the
Anything
question,
else?
ma'am? Yes, ma'am.
Absolutely, ma'am.
So I have 10 days, and then if I don't have all the money in by 10 days, then they have to come back to court to submit something else. And then how many days after that then, ma'am?
Any number of days, ma'am. The court doesn't get involved in how you pay a non-payment of rent judgment. That's something that typically is between you and your landlord. Any
Reason
payment,
why I'm
any payment
asking-
arrangement. Mhm,
Reason
go
why I'm
ahead.
asking, ma'am, is because I was in a car accident. I can hardly move, so I need to know if they haven't got the check from FIA. Okay, and I want to ask another question. What happens if I move out and then the check comes and then what? Because she told me it already been processed.
If you move out and the check comes, you moving out doesn't mean you're not responsible for rent that's come due since October.
No, ma'am, that's
It
not
just
what I'm
means that they won't.
asking. That wasn't what I was asking. I'm sorry for cutting you off. I'm sorry. That wasn't
No,
what I
no,
was
you're not sorry
asking.
for cutting me off because you keep doing it. What's your question? If I'm not answering what you're asking.
I don't want to be disrespectful because I'm not trying to cut you off. I'm sorry.
Ms. McEwen, just, maybe I'm not understanding. If the check comes after you move out,
Yes, ma'am. I know
You should still-
I'm liable for the balance, but I mean, I know the money because what my caseworker told me. So would I be able to move back in my house if they get my money? Is what I'm asking.
that's between you and the landlord. And that's why I'm suggesting, and ma'am, I'm not trying to not answer your question. That usually is just not something, the court never doesn't get involved in that. And attorneys typically don't get involved in it either. They usually direct you to whoever the property manager is. If Mr. Wine has different information, he can share it with you.
Okay. Yes, ma'am. So
Mr. Wine?
Oh, I don't, she has the contact information for my client. She says she's spoken to them recently.
Go ahead, Ms. McEwen.
So I have 10 days for them to get the check. And if at 10 days, then they have to submit something to you. And then will I know that, or do I just get asked? And if they haven't communicated to me that they got the check, do I have to be moved out by 10? I guess that's what I'm asking. Do I have to be moved out by 10 days? Or is after they submit something, then I don't know, ma'am. That's what I'm asking.
Ms. McEwen, I understand your question now, and I can't answer it, not because I don't want to, but just different landlords do things different ways. And that's why it's always best to stay in communication with them. If you have proof that this money is coming, that might be a conversation you have with your property manager or leasing agent or whomever, whatever they call the person that is the intermediary, the person that you talk to, versus not saying anything. If you are in a position to pay some of what's owed, landlords usually want to get paid. They don't want to go through the expense and time of physically removing somebody from the property.
Ma'am, I haven't got any money since December. I'm waiting on my long-term disability, which is supposed to be kicking in on the 25th. I from this car accident. I haven't, if I had money, I would have been paying. But that's what I've been waiting on. I had to wait 90 days before I got paid anything.
Ms. McEwen, you're welcome to give me a call after our hearing, and I can try to walk you through what may very well happen if you do not pay your rent, or if you do pay the rent. Just give me a call. My number is on the pleadings. I'll be happy to go through that with you.
Your number is where, sir?
On the pleadings, the court papers, the
I don't-
summons, the complaint.
Your the 248-559-6400.
You got it.
Thank you.
You're welcome. Thank you, Your Honor.
Thank you. Have a good day. Good luck to you, ma'am.
Thank you.
This is 226195 LT. This is Rawsonville Woods versus Nicholas Vercruci and Johanna Magard. If I messed up your name, sir, my apologies. Mr. Morton, your appearance, sir.
Your Honor, Attorney Ian Morton of Palace Law on behalf of Rawsonville Woods. If I may, the parties have spoken and have agreed to enter into proposed consent judgment agreement. As of today's date, rents retained are $3,453.90, core costs of $198, for a total of $3,651.90. The payment/writ date will be the 29th of March, Your Honor. I've also went ahead and advised both parties of their, rights under MCR 4.1, which includes the 3-day time period in which the judgment will not be final for, as well as their right to appeal. Further, they both did give me permission to put their name on the proposed consent judgment agreement, which we would then submit to the court after this hearing.
Thank you. Tenants, if you would unmute yourselves and state your names for the record, please.
Johanna Maggard.
Nicholas Vercruci.
Sir, ma'am and sir, you were able to hear Mr. Morton just now?
Yes.
Yes, Your Honor.
And it's your agreement to have the Sarah stay lifted and a consent judgment entered showing past due rent of $3,453.90, $198 in court costs for a total judgment of $3,651.90.
Yes.
Yes, Your Honor.
And you've agreed that you will pay this amount or move from the property by March 29, 2023.
Yes.
Yes, Your Honor.
And Mr. Morton explained to you that because the property is represented and you are not, the judgment will not be final and enforceable for 3 days.
Correct.
Yes.
And then last question, because you appear on Zoom, there is not a signed consent judgment. You've authorized Mr. Morton to sign your name to the consent judgment that's presented to the court.
Yes, Your Honor.
Yes.
Thank you. Mr. Morton's office will prepare that judgment submitted to the court for entry. Once I sign it, copies will be mailed to you at the addresses as they appear in the court file. Anything else in this case, Mr. Morton?
No, Your Honor.
Any questions, Mr. Veracruz?
No, not at this time.
Any questions, Ms. Maggard?
No, Your Honor. Thank you.
Thank you for your patience this afternoon. Have a good afternoon. Good luck to you.
Thank
Thank you.
you, you as well.
Thank you. This is 225048 LT. This is Anamark Concord Club versus Calvin Mitchell.
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of Anmark Concord Club.
Today is the day and time set for hearing on the plaintiff's request to lift the Sarah stay. The case was scheduled at 1 o'clock. It's now 1:21 by the court's clock. Calvin Mitchell or anyone from 6966 Niagara Apartment 100 in the city of Romulus. Defendant having failed to appear, Mr. Morton, how would you like to proceed?
Your Honor, at this time, we'd ask a default judgment for possession to be entered. Rents retained are $7,677.01. Court costs of $164, total of $7,841.01. This was after the lift of a Sarah stay that we're seeking, as the payment had not been brought current.
Thank you. Sarah stay is lifted. Default judgment shall enter in favor of plaintiff and against defendant with total due of $7,841.01. Standard 10-day pay or move. This is 226054 LT. This is 226113 LT. This is Park Estates versus Susan Gunderson.
Good afternoon again, Your Honor. Danny Horn, P81774 for the plaintiff.
Mr. Horn, today is the day and time set for hearing on plaintiff's request to lift the Sarah stay. This case was scheduled at 1 o'clock. It is now 1:22 by the court's clock. Susan Gunderson or anyone from 69 Park Estates Drive, Belleville, Michigan. No response. Defendant having failed to appear, Mr. Horn, how would you like to proceed?
Your Honor, if you wouldn't mind passing on that momentarily, I don't have that file in front of me and I don't want to give the court incorrect numbers. So I will have to confirm with those, with that information. I just don't have that file in front of me and I can't speak to that at this moment.
Absolutely.
Thank you.
This is 226119 LT. This is Park Estates versus Kenda McLaren or anyone at 6 Brandy in Belleville.
Danny Horn for the plaintiff, P81774. Same thing, Your Honor.
Is it going to be the same response in all the Park Estate cases, Mr. Horn?
No, we actually have a conditional dismissal that was submitted early March for one, and then 2 of them are moving forward. Those are the 2 that I have for Palmer and Thomas. 563 and
Morgan and
564.
Thompson, maybe?
563 and 564.
I don't have those, sir.
Well, okay.
I have Park Estates versus McLaren, Stephen Morgan, which is 121, Callie and Alan Thompson, which is 129.
I don't have any of those. I'm not certain what the mix up was on this. And I apologize for that, of course.
And then we have Huron Estates, which is 241 Angela Dudek and
Yep.
Art Stillfried.
Yes, I have that as well. And then I've also got Belleville Manor, Hamlet 623.
I don't have that Belleville Manor one. I don't know what docket you have. But I'll
This was-
call Mr. Casas' case so that you can,
Thank you.
that's the only Huron Estates one. This
That's
is
correct.
226241 LT. This is Huron Estates versus Angela Dudek and Art Stillfried or anyone at 22015 Latour, number 49 in the city of Romulus.
Again, Danny Horn for the plaintiff.
Today was a day and time set for hearing on plans requested with the Sarah stay. This case was scheduled at 1 o'clock. It is now 1:25 by this court's clock. Defendant having failed to appear, Sarah stay will be lifted. Mr. Horan.
Thank you, Your Honor. Due to the defendant's failure to appear, we would request a possession default judgment. Rent is $3,658.74. Cost of $199.14 for a total of $3,857.88.
Defendants having failed to appear, default judgment shall enter in favor of plaintiff and against defendant with total due $3,857.88. Mr. Horn, if you want to check on the other matters.
Yes, thank you. And again, those are Thompson 129. I heard Gunderson.
McLaren 226119. Morgan 6121.
Okay. And excuse
This-
me, the Gunderson matter, what was the ending in that one?
6113.
113. All right, thank you.
Thank you. This is 226218. LT, this is Green Meadows Apartments versus Jones. Your appearances, please.
Your Honor, for the record, Attorney Ian Morton of Palace Law on behalf of the plaintiff. Mr. Webster is the community manager, Your Honor.
Right. Today is the day and time set for the hearing on plans requested with the Sarah State. This case was scheduled at 1 o'clock. It's now 1:27 by the court's clock. Defendant having failed to Shayla Jones or anyone at 11685 Meadows Lane in Belleville. Defendant having failed to appear. Mr. Morton, how would you like to proceed?
You're out this time. This is after a seer stay. We'd ask a default judgment for possession be entered, the seer stay be lifted. Rents retained are $7,610.38. Court costs of $164, for a total of $7,774.38. We would ask a default judgment for possession be entered at this time.
Thank you. Based on the defendant's failure to appear in this matter, the Sarah State is lifted. Default judgment shall enter in favor of plaintiff and against defendant with total due of $7,774.38. Plaintiff's office will submit that judgment for entry with the standard 10-day to pay or vacate. Anything else, Mr. Morton?
No, Your Honor, I believe that's the last matter for the day for me. So
Thank you, sir.
thank you as well.
Have a good day.
You too.
This is 226054 LT. This is Wellesley Townhouses versus Moody. State your name for me, please, ma'am.
Quaternions, Moody.
Ms. Moody, today is the day and time set for a hearing on plaintiff's request to lift the Sarah stay. The plaintiff has failed to appear this afternoon.
Oh.
What's going on in this case? Do you know?
Sarah, I applied for Sarah and they said that they don't have any funds available. So I am going through the MVAA, which is a Michigan Veterans Affairs Agency, to see if they can pay any partial. But I was also going to talk to the landlord about making some payments. Since that, they sent me an email last week letting me know that they were out of funds. So I have a meeting with them on Friday with the VA.
Well, ma'am, the plaintiff requested the Sarah stay be lifted. They have not appeared. The court will lift the stay and schedule the matter for pretrial. That is what was indicated on their paperwork to the court. The court will
Okay.
get this back on the docket for April the 5th
Okay,
at 10 a.m. They'll be back here with me, back on Zoom,
okay.
okay?
And they'll send me something in the mail for that date?
No, notice would be, yes, the civil department will mail notice to you
Okay,
and again to the attorney for Wellesley Townhouses, okay?
okay. Do I know the balance on that, or you don't know that, right?
I don't have that balance. You
Okay.
might want to call your landlord, or I don't know if you have an electronic portal or something you can log on to look.
Okay,
Anything
Will
else,
do.
Ms. Moody?
no, ma'am.
Have a good afternoon, ma'am.
You too, thank you.
Thank you. Any luck, Mr. Horn?
Yes, I did locate the files. I did want to have an opportunity. We do have a representative, Ms. Kobish is here from Park Estates. I know on a number of them, there was some payment plans that were entered into, so I would just ask her when we call the case to be able to speak a little bit as to what's going on with the status of that. Of
Give me 1 second,
course.
please. Mr. Ravitz,
Good afternoon, Judge.
good afternoon, sir. How are you?
I'm fine.
I called this case at 1:20-ish. Miss Moody was here. I lifted the Sarah stay and set it for a pretrial on April the 5th.
We were given the wrong
Yeah.
number, Judge.
You were given the wrong which number?
We were told to zoom in on 941-327-7643. And I was in that waiting room for about 35 minutes.
Ugh. I knew it was unusual for you not to appear, and that's why we reset the matter. My next landlord tenant docket is the April 5th at 10 a.m. She indicated that she's waiting for, Miss Moody indicated she's waiting for assistance from the VA. I indicated she should stay in communication with the complex. So I'm not sure what happened with your notice, but,
Well,
oh, she did ask the balance. That was the other question Miss Moody had, was the balance that was doing owing.
she's not here, so I can't give it to her.
No,
I can
she-
give it to
right.
you.
She left.
Okay, well,
I would say if you want to have your client reach out to her and provide her the balance, there might be some different communication you can have with her before the April 5th date.
okay, we'll do. Hope you've been doing well, Judge.
I have been. How have you been?
I've been great. No major complaints.
Good.
Okay, well, I guess I'll see you on April 5th at 10 o'clock.
Unless you resolve it before then.
Yes, okay. Thank you.
Thank you, sir. Uh, 226113 LT Park Estates versus Gunderson. Mr. Horn, you indicated that you might have some information.
Yes, Your Honor, I've got Kim Kobish here from Park Estates that can fill us in. There were some payment plans that were entered into for these cases, so I would ask if you need to swear her in before then, we can do it that way, but happy to fill in as much as we can. Belleville.
Well, we're here on the plans request to lift the Sarah stay. Did your client receive Sarah money? And by Sarah, the court means generically emergency relief funds.
No.
No. The stay will be lifted. And then Ms. Kovish, if you would raise your right hand, ma'am, do you swear affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
What is the rent that remains due and owing in Ms. Gunderson's matter?
Let me get that. Currently, she owes $1,779.35.
And then court costs?
Court costs were $153. I gotta go way back. Sorry.
That's okay.
Yeah, $153.
This case was scheduled at 1 o'clock. It's now 1:39 by the court's clock. Ms. Gunderson has failed to appear. The Sarah stay has been lifted. Mr. Horn, your client has provided the rent to retain possession is $1,779.35. There's $153 in court costs for a total judgment of $1,932.35. If your office would submit a judgment to the civil department showing that amount, the court will enter that judgment by default.
Thank you, Your Honor.
This is 226119 LT Park Estates versus Kenda McLaren or anyone at 6 Brandy in Belleville.
Again, Danny Horn for the plaintiff.
This case was scheduled at 1 o'clock. It's now 1:40 PM by the court's clock. Defendant has failed to appear. The Sarah stay is lifted. Ms. Kobish, you remain under oath. The past due rent
right now, $1,010.89. And she is on a payment plan.
The court costs, ma'am.
Let me get that. These were put in a long time ago. 153.
It's a total of $1,163.89. You indicated she's on a payment plan.
Yes, we did like payment plans back in December with some residents that were having trouble paying. So she's got a signed payment plan here, and she's due to have her last payment in this week. So she'll be caught up.
That being the case, Mr. Horn, how do you wish to proceed, sir?
Ms. Kobish, would you prefer to have a default judgment enter at this time and give her the 10 days? Is that what you would like to do?
Yeah, and I'm sorry, I forgot about Miss Gunderson too. She actually, all these people here, Gunderson, McLaren, and Morgan are all on what we call like our payment plan to help them get caught up.
Right,
Okay.
so would you like a judgment to enter today for Ms. McLaren?
Sure, because she'll be paying, I know she's gonna pay, so yeah, just to keep her.
The default judgment will enter with the $1,010.89 in rent, 153 for court costs, one total judgment of $1,163.89. Mr. Horn's office will submit that for entry
Thank you.
with the standard 10 days. This is 226121 LT. This is Park Estates versus Stephen Morgan.
Danny Horn for the plaintiff.
Okay, now, Mr. Horn, it makes sense. What happened is, and this is the court has concern, Mr. Graham Mason appeared on these cases back on January 11, 2023, and indicated to the court that they would be resolved. Some of them were by conditional dismissal, some of them were by consent judgment, and the court did not receive any of those documents. So let's go back. That's what the issue was in Gunderson. So there was not a Sarah Stay. There was Mr. Graham Mason was supposed to have documents filed with the court. Same thing in McLaren, same thing in this case. His indication on the record was that his client was working things out and that they would be submitting, the client would be providing you with signed conditional dismissals and consent judgments with a notice of right that they have, that Ms. Kobish's office would have tenants sign off on. That's why these cases are back on the docket. The court staff did not want to put them on the no progress docket, but it was your office's failure to submit the documents resolving the cases. That's why these are back on. But the same thing in this case, the Stephen Morgan case, this case was scheduled at 1 o'clock, is now 1:44 by the court's clock. Mr. Morgan is not here. The indication from January 11th was that the consent judgment would be submitted. What's the status of this matter?
He currently owes $124.82.
At 124.82, is it past due rent or is it something else?
Nope, it's not. It's just he forgot to pay his late fee, and he had a small balance from this month.
That being the case, Mr. Horn, how do you wish to proceed?
Ms. Kobish, on that one, I would recommend that we dismiss the matter for being such a low amount.
Okay.
So, Your Honor, we would
If your
request,
office would submit that, Mr. Horn.
of course.
And then the last case is 226129 LT. This is Park Estates versus Alan Thompson and Cammie Thompson. Same thing. Mr. Graham Mason appeared in this court on February 7th, 2023 with Miss Cammie Thompson and indicated to the court that a conditional dismissal would be submitted. The court has not received anything as of yet. What is the status of this matter, Mr. Horn?
There's no conditional dismissal that's been reached. Ms. Kobish may have information regarding a separate payment plan that they've entered into, but we did not get a signed conditional dismissal.
They are actually paid in full.
Great, then we will submit a dismissal on that one as well.
If your office would be so kind, thank you, sir. That concludes this course docket. I don't have any more files.
All right,
Thank you for
Your
looking
Honor.
into those matters, and thank you for your assistance, Ms. Kobus. You both have a wonderful afternoon.
Thank
Thank
you.
you,
as
too.
well.